Good afternoon, everyone. This is the Office of Consumer Credit Commissioner's stakeholder meeting to discuss the rule review for credit access businesses. My name is Matt Nance, and I'm the OCCC's Deputy General Counsel. I'm joined by several members of the OCCC staff, including Commissioner Leslie Pettyjohn, General Counsel Michael Rigby, Director of Licensing Moran Diamond, Director of Consumer Protection Huffman Lewis, Senior Supervising Examiner William Purse, Supervising Examiner Christy Graham, Financial Analyst Carl Hubenthal, Assistant General Counsel Audrey Spalding, and Paralegal Ginger Harmon, who's acting as our meeting organizer. We are holding this meeting through an online webinar. Normally, we like to hold these stakeholder meetings both in person and online, but like everyone, we are, of course, following developments with the coronavirus, and to help promote everyone's safety, our building is currently closed to the public. We thought that holding this webinar would be a good way to be transparent in our rulemaking while also being safe, and I look forward to the next time I can see you all in person. I want to thank everyone for joining our webinar. Getting input from stakeholders is a really important part of our rulemaking process, and these meetings help us make sure we can produce the best rules possible. We're holding this meeting on GoToWebinar. Some of you might be listening on your phones, some may be watching on your computers, and some may be doing both. For those of you watching on your computer, there's a window where you can submit questions. If you have technical questions about using the webinar, you can type them in there and Ginger will try to answer those. If you have any comments on the notice itself, go ahead and type those at any time and I'll be getting to those as well. And if you're on a computer with a mic, there's a function allowing you to raise your hand and then we can let you make a comment verbally. We are talking about rule amendments that are coming out of a process called rule review. The Texas Government Code requires state agencies to review their rules every 4 years to make sure they should still exist and to make any necessary updates. And when we do that, we try to get input from stakeholders on whether the rules should be updated. The rules governing credit access businesses in Title VII, Chapter 83, Subchapter B of the Texas Administrative Code are currently up for review. So I'd like to first summarize these rules and then lay out the proposed timeline for the rules, and then you'll have a chance to provide comments. There are 8 different sections with proposed rule changes coming out of rule review. In section 83.2003, we are proposing changes that would provide examples of a device, subterfuge, or pretense to evade the application of the subchapter governing cabs. This is connected to an issue that the OCCC recently discussed in Advisory Bulletin 20-1. We found that in some transactions, cabs were providing cab-specific disclosures in non-cab transactions, leading to some possible confusion for consumers. So these rule changes would try to address that. In section 83.4003, the changes relate to our review of a cab applicant's criminal history. The amendments include some technical corrections and updates to citation based on some recent legislation. That's HB 1342 from last year. We are proposing repealing section 83.4007. This section deals with reissuance of a paper license certificate and is no longer necessary with the OCCC's online licensing system. In section 83.5001, there are amendments on our enforcement practices for reporting violations. Because our practice is to issue a warning for the first violation, we'd remove a reference to a penalty for the first violation. We'd also add a statement on revoking for failure to pay a penalty from a final administrative penalty order. The situation where a cab fails to pay a penalty is pretty rare and typically happens when a cab has ceased doing business. In section 83.5003, the amendments would simplify the witness and records declarations that our examiners use to obtain statements and records. And in section 83.5004, the amendments would clarify record-keeping requirements for threats or referrals for criminal prosecution. In section 83.5005, a new rule would have standards on separation between a cab and a third-party lender. This is to ensure that the cab obtains extensions of credit by others, as stated in section 393.0013 of the Finance Code. I think the separation requirement is widely understood in the industry, but this rule would help give some clear guidance to the industry and ensure that we as an agency have the tools to administer the statute and that our examiners can verify compliance. In section 83.6007, we have updates to the 4 cost disclosures to include updated information about the costs of other types of credit, as well as the stick figure disclosure in the bottom left corner of the disclosure that has patterns of repayment. So here's the proposed timeline for the rules. You can see that we're requesting informal pre-comments by May 27th. We intend to propose the amendments at the Finance Commission's June 19th meeting. There will be an official comment period during the month of July. We present the rules for adoption at the Finance Commission's August meeting, and the rules will be effective in early September. This is a tentative timeline, and we're interested if you think a different timeline is appropriate. In particular, the last time we updated the CAB cost disclosures, we had a delayed implementation date where CABs could continue using the previous disclosure for a period of time. And we're interested to know whether stakeholders think that's appropriate this time as well. So with that, I've summarized the rule action. And Ginger, are there any comments on any of these rule amendments? Again, I want to remind everyone that there are 2 ways to provide your feedback through this webinar. First, you can type your comment out and send it to us through the webinar's question feature, or if you're on a computer with a mic, there's a function allowing you to raise your hand, and then Ginger can recognize and unmute you. So Ginger, do we have any written questions or comments through the webinar, or anyone who's raised their hands? Okay, I don't see any. I'll wait at least 1 full minute. Oh, okay, we have some questions coming in. I'm going to stand by for Ginger to send those to me. Okay, we have one question through the chat. Do y'all have a text of the proposed rule amendments yet? So yes, we do. The rule text is available on our website. The OCCC has a web page with rule updates. And if you go to that page and click on the link that's Credit Access Business Rule Review, the first couple pages of that are the meeting notice for this meeting, but then after that is the text of the proposed rule action and the disclosures. So that's that rule webpage. It'll be on the last slide when I conclude this presentation. There'll be that link. But if you follow the link to that page, and then on that page, scroll down to Credit Access Business Rule Review, you'll be able to see the text of the proposed rules. Okay, we have a question from Ann Bador. How would the subterfuge language apply to circumstances not specifically outlined in the new proposal? So one issue with device or subterfuge, and there was a recent Attorney General opinion that analyzed this and acknowledged that this is a factually specific question. So I don't really know how to answer the question of how the text applies to situations that aren't in the text, but I would just note that device or subterfuge is a factually intensive question, but we invite comment on should the rule address additional types of situations, what changes do stakeholders suggest to the wording? Okay, next question from Craig Bennett. I would like to understand more of the purpose behind the change to 83.50058. And let me pull up my draft of the rule real quick to remind myself which one that is. Okay, so this would be the new provision saying a licensee may not directly or indirectly share fees with a third-party lender. If a third-party lender receives any portion of a fee charged by a licensee, it must be promptly remitted to the licensee. And this is to ensure compliance with the requirement that the loan be made by someone other than the credit access business under section 393.001. The issue with sharing fees and kind of the problem there is that if there's sharing of fees, it might result in the lender collecting interest that's greater than 10% per year and engaging in unlicensed activity or charging usurious interest. So that was the rationale there. Okay, we have a hand raised by Rob Norcross, and Ginger, I will let you unmute Mr. Norcross so he can share his comment.
I'm good.
Oh, unmuted. There you go. Matt, how are you?
Doing well. How about yourself?
Good, good. Doing fine. Doing fine. Couple comments on, we'll start with 83-2003. I'm curious as to the thought behind striking the language at the bottom of the page and including number 1 and number 2. The question would be, why not leave the language that was there and add 3, 4, 5, and 6? Am I missing something there? Is there something that is being done that I'm not seeing?
Rob, I think our intent was to simplify it. So, you know, it simplifies the text a little to just say if it is a deferred presentment transaction. I think our thought was that that's a little bit simpler and more plain language than in substance meets the definition of. So I think it was an intent to simplify and make the rule a bit plainer. But you know, we're open to suggestions if you think that you know, different text is better. But yeah, we're interested in knowing more about, okay, would that text work better, and why would it work better for stakeholders?
Yeah. Okay. I got it. Let's see. I'm assuming that we're going, and I've just got 2 or 3 things here. I'll be quick. That we're going to, we're going from written statement to declaration because that matches the Civil Practices and Remedies Code.
That's correct.
83-5003. I'm assuming declaration it matches the other codes, and that's why we're doing that.
Yes, that's correct.
Okay. The other, let's see, 2 more things, I think. In 83-5005, in 3 and 4, the everyday functions of a third-party lender seems, I've had some comments from folks that represent some of the companies in our association where that seems a bit broad or vague. Maybe vague's better than broad. And then went down in 7 on the general agent or joint venture relationship. I think what I'd like to do is suggest some language and I'll put it in a written comment. I'm not exactly sure I've got it all hammered out yet, but it talks about a special limited agent pursuant to a written agreement, because I think that's what most everybody does. And maybe it's a way to say 7 what you can do as opposed to what you can't do. I don't know. I just wanted it seemed to me that there may be a way to make that a little more consistent with what most everybody does. And I don't know about the everyday functions of a third party lender. I mean, I think I know where you're going, but that may cause arguments. I don't know. So that's not really a question. That's a statement saying that we're working on some language. I just want to give you a heads up.
Okay, so would that language be more like a licensee must, and then you would describe what the licensee must do?
Yeah, I think so.
Okay.
I think must or should, but I think must is better. And then the last question I've got, and I know there's some other people that are listening in that may have some more on this. When you go to subparagraph C in that same section, 835005, where it says the OCC may consider the following factors in determining whether a licensee operates independently from a third-party lender. I just wanted to ask the question. It says may consider the following factors, which I think is a good approach, as opposed to trying to draw bright lines, because in many places there aren't bright lines. I just wanted to ask, there are some, I'm not sure that I know of any that are still out there today, but I know that there are a couple of, or there have been in the past, a couple of familial relationships that were legitimate between a parent and a next generation child, or a parent and a grandchild. For example, a situation where father's had an investment company for 40 years and is doing very well, and son or grandson decides to go into the cab business, and they have separate financing and separate directors and all that sort of thing. I think that's okay. Now, we've got a community property state, so you can't have a husband and a wife, and you can't have like a minor child's trust being the lender for the parent that's contributing money to the trust. I mean, there's all sorts of family relationships that aren't legitimate. But I guess my question is, as long as it's may consider the following factors, then I think we're good, because you can dive into it on a case-by-case basis. And I just want to raise that. I don't know if anybody else that's listening in on the call has comments there. I mean, I know we want to make sure that there's no affiliation between cabs and lenders. But there may be I can imagine a familial relationship that would probably be okay, although I don't think it would happen often.
Okay. Well, that's good to know. If you would, like to share any of those examples in a pre-comment, we'd be happy to look at them. It sounds like the general structure that you're amenable to that.
Yeah, I think the structure of the section's fine, and I'll add that in our comment.
Okay.
And on the charts, real quick, last thing. I'm assuming, when you did the stick figures and the cost analysis and that sort of thing, what's the time period? Was it the last year? Was it the last couple years? mean, I think it looked fine. I was going back and looking at some of the reports, and I was having trouble figuring out, you know, what I know Carl probably knows the answer to this. What the time period is for?
Yeah, the time period is 2019
Okay.
for the stickers.
And you know, if you know, you were talking, you raised a good point. I hadn't remembered that we had a implementation period on that. I have to go back and look. Do you remember offhand how long you guys gave everybody to get their computer systems reprogrammed to get the new stick figures in there?
Off the top of my head, I don't remember the exact period, but it was a few months.
Yeah. Well, I don't know if we'll need as long this time, but you might. I'll go back and try to dig that out. We might do something similar. I mean, I don't know that we'll need, since everybody basically has the format set up, maybe, you know, 60 days is better than 90 or 120. But that's probably a good idea because people are going to have to do some reprogramming. But anyway, I guess one thing that we could, well, I'm going to plan on telling everybody, and then I'm going to shut up, is that since you're using actual data from 2019, my guess is those 4 pages, those 4 disclosures aren't going to change, right? Because it is what it is. I mean, you're using historical numbers. So if people wanted to go ahead and kind of get a jump on things, they could probably do that.
No, I would tell folks to wait until the new disclosures have been adopted and gone into effect, because at this point, this is just a proposal. Our oversight body, the Finance Commission, has the final authority to adopt the changes, you know, following a proposal. So and from what I understand, the data is kind of preliminary. There might potentially be some corrections to it. So there might be some slight changes there.
All right, fair enough.
Between now and adoption.
Okay, thank you. Thanks, everybody. I'm done.
All right, thanks, Rob.
We could, you know, my wife would like to figure out how to do that.
Okay. All right, thanks, Rob.
Right.
Okay. We had a couple written questions that I want to get to. So from Craig Bennett, referring again to 8350.058, is this just supposed to be CSO fees? And I think, this is a licensee may not directly or indirectly share fees with a third-party lender. And I think that, yes, our thought was that that's referring to the CSO fees, and the licensee not sharing the fees that it takes in with the third-party lender. But you know, if the CSO were collecting some other fee, that's any fees for its services. So if you mean fees collected by the CSO, then I would say yes, that's the CSO fees. Question from Martin Jetchev. If we believe that Subterfuge is being committed, what kind of documentation or evidence would the OCCC consider sufficient to trigger an investigation? So that's going to be governed by the Texas Finance Code. We would need, well, first of all, I'd encourage someone who believes that to file a complaint with our Consumer Assistance Department. Our Consumer Assistance Department can work with other governmental entities on kind of working through a complaint. And so that would be kind of the the stage of gathering information to determine, can we resolve the issue there, or does it warrant an investigation and gathering more information? But generally, under the finance code, we would need, reasonable cause to proceed regarding violation. But if someone has that evidence or information, I'd encourage them to contact our Consumer Assistance Department. Okay, and looks like we have a hand raised by Steve Camp. So I will let Ginger unmute Mr. Camp.
Mr. Nance, thank you. We had 3 concerns. I primarily represent third-party lenders in my legal practice. And so our first concern would be on the concept of sharing of fees. And we certainly are in agreement that CAB fees belong to the CAB, interest belongs to the third-party lender, and the late fee that might be charged in connection with a late loan would belong to the lender. But there's another fee that is not interest under the Texas Finance Code, which is a return item charge. And frequently, in order to benefit the consumer, the CAB is authorized to debit for the fees that are owed to the consumer, and the lender is authorized to debit for the amount that is owed to the lender. But for the convenience of the customer, that is frequently submitted as one ACH, and that it is split out. If there is no sharing of fees, then the return item charge of $30 would go to the person who submitted the ACH, and that would probably result in multiple ACHs being submitted, one by the CAB and one by the lender, which would, if returned, duplicate fees and increase the cost to the consumer. So we would be concerned about the application of the no income sharing with respect to that late or that return item charge, which is not interest under the finance code.
Okay, thank you.
We would also have concerns about the issue of the family relationship. Again, I have represented CABs where the father is a successful business person, has operated a finance company. His child has entered into the CAB business, and the father has acted as the third-party lender. There is no ownership interest. There's no joint control. Again, there's a family relationship, but the estate planning was such that if the father were to pass away, the son who operated the CAB business would have no ownership interest in that third-party lender. So we're concerned about the application of the family relationship rule. Additionally, we are concerned about the vagueness of the everyday operations. We believe that there needs to be some level of specificity as to what the OCC is attempting to regulate, because what we would like to do is ensure that all of our customers are in full compliance with your guidelines and don't want to have any room for crossing over the line in terms of what you're looking for in terms of everyday operations.
Okay, thank you. Mr. Cam, did you have anything else?
That's all. Thank you.
Okay, thank you. Okay, I got a message from William confirming that the last time we updated the Stickier Disclosure, we allowed a 30-day delay for licensees that did not use pre-printed forms, and approximately 6 months for licensees that used pre-printed forms. And Mr. Norcross has raised his hand again. Ginger, would you unmute Mr. Norcross?
Oh, Matt, I screwed up.
Okay.
I didn't mean to re-raise my hand, but I
No
appreciate
worries.
I appreciate the note from William,
Okay.
and I'm trying to lower my hand.
Okay. Thanks.
All right.
Okay. Ginger, did I catch all of the questions and comments that have been submitted? I'm scrolling back up just to make sure I've addressed them all. Oh, we have more questions coming in. Okay, so a question from Rachana Chin. In proposed rule 835004, the OCCC wants to clarify that a licensee must maintain all records of threats of criminal prosecution and information provided to law enforcement alleging criminal conduct, not just file criminal charges and complaints. How would that data be used by the regulator? For example, could that data be the basis of an enforcement action as grounds for denial, suspension, or revocation of a cab license under 7 Tax Section 83.4003F? So the question is, how would we use that information by the cab? Primarily, this is in our record keeping rules, so this would be used by our examiners. And during compliance exams, our examiners go to confirm that the licensee is complying with the law and provide instructions on how to address violations if they are not addressed. If a licensee doesn't follow the exam instructions, that could be the basis for an enforcement action. Those records might also be used in complaints. For example, if a consumer complains that a licensee has pursued criminal action against the consumer, we would then be able to review those records of the licensee and determine how to proceed. What does the licensee need to do? Was there a violation? And if so, what does the licensee need to do to address that? So it could potentially lead to enforcement. It's a little bit different. The rule at 834003 that's more in the situation where a principal party of a credit access business has been convicted of a crime. So it's a little bit of a distinct situation. Okay, we have another hand raised from Rob. Rob? Ginger, could you?
I'm mystified.
Okay, sorry.
It shows a red arrow pointing downward.
Okay.
It says I've
We
lowered
will. Sorry about that. We'll
no, that's all right. If I've got anything else to add, I'll call you.
Yeah, just shoot a message to Ginger if you.
I will. I will.
Okay.
I'll type it out if something else comes up.
Got it. Okay. We have another hand raised from Robert Wheeler. So Ginger, if you could unmute Mr. Wheeler.
Mr. Nance, good afternoon. Can you hear me?
Yes, I can hear you.
Okay, perfect. Just two questions. One is regarding 83-5005, Section 8. Just want to elaborate a little bit more on directly or indirectly sharing of fees And just so just a couple of questions I have from a few of my clients in regards to, indirectly say, later on or in another business somewhere, say in the oil and gas business, if they happen to invest in that business together, obviously the cab acquired some of his funds from his cab business. He may go into a separate business or invest in another business. I guess the word indirectly seems kind of broad in that sense. Directly is very clear, but indirectly is where the question's coming up. And the second question is, another concern is their ability to get access to the resources to respond to your proposed rules here in the timeline that you've displayed when you first opened up the comment period here. They have limited availability to fly, access to hotels, so they're not able to visit their attorneys who may be in Texas or other states who are reopening under different time frames. And they just ask, could we just delay the response time, 30 or 60 days from the May 27th deadline to get responses back in, just due to the current situation that's in Texas and across the U.S. and across the globe. And that's all that I have.
Okay, so yeah, if any proposals to delay, especially if there are business concerns around the COVID-19 pandemic, we are interested in hearing about those. I would note there will be another opportunity to provide official comments before these rules fully go into effect. So as I said when discussing the timeline, assuming we proceed with proposing the amendments in June and adopting in August, there would still be another 30-day comment period during the month of July, and the amendments wouldn't go into effect until September. So I just want people to keep in mind that there will be time to review the rules and comply. But we're interested in hearing suggestions, and if there's some delay or some delay of part of the rule that would help stakeholders, we'd be interested in knowing what do stakeholders propose and how would that help them.
Thank you. And I guess the other question was in regards to Section 8 of 83-5005. If you could elaborate a little bit more on what indirectly sharing would be of those fees.
Yeah, so indirectly, I know in some cases or certain contexts, our examiners might see like, you have two companies, and instead of, a transfer of money from one company to the other, like one company provides a discount on some service. And so that's kind of an indirect sharing. But, we also, so that language appears in some places in the finance code. So that's kind of a concept we've used to ensure that there's not an end run around some prohibition on sharing fees. But yeah, if stakeholders have any suggestions about phrasing that to address situations they consider legitimate, we're interested in hearing about that.
Okay, and I think it was 2015 or 16, the last time that we had the rule review and proposal. I think it was at the Finance Commission. I think it was about the fees or about the relationship between the lender and the cab about being direct or indirect. And I wasn't sure if but either one. I remember that the Finance Commission didn't like the word indirect. I think we had to take that out. But I wasn't sure if it was with the fees we're talking about, or we were talking about the relationship between the third-party lender and the cab. But anyways, thank you for answering the question, though. Appreciate it.
Okay, thank you. Do we have any other questions or comments? Oh, and if you want to type a longer question, feel free to just put in a short statement that you're typing a longer question, and we can wait for that. Okay, I'm not seeing any other questions or hands raised. So I'm going to wait 1 full minute just to make sure everyone's asked whatever questions they want to ask. Again, if you want to type a longer question, just send in a statement that you're typing a longer question. Okay, it looks like we have no other questions or hands raised. So I want to thank everyone for joining us and participating. Rule updates, as always, are available on the OCCC website, and we'll also be posting the audio of this meeting to the agency's YouTube page, and there'll be a link on our rule page, the link displayed on the bottom here, occc.texas.gov/publications/rules. We are accepting written pre-comments on these rules until 5 p.m. Next Wednesday, May 27th. You can email those to me at rule.comments@occc.texas.gov, which is our email address for rule comments. Thank you all for attending. Please be safe out there. Take care of yourselves, take care of each other, and we will see you next time. Thank you.